Let me give everybody the roadmap about what Donald Trump's going to try to do to help Ghislaine Maxwell after the United States Supreme Court has refused to hear her appeal regarding her claim that the non-prosecution agreement, that sweetheart deal with Jeffrey Epstein, applied to her as a co-conspirator. And then she thus claimed that she shouldn't have been criminally prosecuted, that there was a contract, in essence, with Jeffrey Epstein that she was a beneficiary of, where she shouldn't have been prosecuted. Southern District of New York, federal judge didn't buy it. Second Circuit didn't buy it. Supreme Court didn't even want to hear it. Now, one of the concerns that I had was that Donald Trump was creating a record for Ghislaine Maxwell after. I always thought the Supreme Court was not going to take up the case or listen to it. It'd be easy for them just to reject it in one line like they did. But now what happens? I want everybody to think about this. How compromised Donald Trump is, that what's her next move? Where does she go next? Well, she can't appeal anymore, her conviction. That's done. So now she's sitting in this Texas camp, this minimum security facility where she doesn't belong, because convicted sex traffickers are not allowed to be there, especially convicted child sex traffickers. But Donald Trump got the exemption from the Bureau of Prisons, and that's where she's at. But what's her next move? Well, she's going to either try to get a pardon, which she's trying to do from Donald Trump, or get a pardon from him, and or she's going to file, and she's hinted at this before, something called a habeas petition or habeas corpus petition to the district court. And what she's going to argue is that there's been new evidence that's been discovered that wasn't available to her, and that this is an exceptional circumstance, that we need an extraordinary writ to come in and open up the case anew because there's new data. Just for everybody thinking about it, thinking about habeas petitions, like a lot of those cases that got famous early on, within the podcast world, which, in the Innocence Project and organizations that would find evidence later on, but meritorious evidence later on, to clear the name of someone wrongfully convicted for decades or a long time. You know what I'm talking about? They would file what's called habeas petitions. Now, what is Ghislaine going to argue? She doesn't really have anything meritorious. She doesn't have anything meritorious. Okay. She's a vile, convicted sex trafficker. That's who she is. She was rightfully convicted, and it was just the tip of the iceberg, I think, what they actually prosecuted her for. But what's she going to argue? The same way in those other cases that you may be aware of, they said there's new evidence, right? Sometimes it's DNA evidence, it's this or that. She's going to say, guess what? Donald Trump, the president of the United States, has said it's a hoax. And all of these people are saying that somehow James Comey, the former head of the FBI, was involved with his daughter, who was the lead prosecutor of my case, and that was never disclosed, that, James Comey somehow tampered with my files. And, Donald Trump and all these people are saying that there might be issues with the files by the Democrats. And so I never knew this. Folks, the president of the United States, the deputy attorney general, all the vice president, that head of the FBI, the attorney general, they're all now basically claiming that there were defects that were here, that they can't release the files now. So I should be able to get a new trial because I want to introduce evidence of hoax. Now, a federal judge will likely discount that and say, nah, that's just Donald Trump saying a bunch of crap, and that doesn't come in. But I just want you all to think about it. Let's put it in the context of another case that was federally prosecuted during normal times, not Trump times. Let's just use the Obama administration as an example. So imagine if Obama and his attorney general on any specific case, they would never even comment on a specific case. They wouldn't even talk about specific cases. The standard line was, we don't get involved in that. We don't do that. We don't even, but imagine they got involved. And that Obama made a statement. You pick the case of who it is. And he goes, and then the FBI head, and then the AG all said together, yeah, we looked at that file. It's a hoax. Of course the person's going to get a new trial, right? I mean, the president of the it wouldn't even be a question that they would get a new trial. You would cite, it would be judicial notice. The president, the FBI, they said hoax. The federal judge would give it to him right away. But now just think about, it's an example of not just the idiocy and the dangerousness of Trump's rhetoric, but also that the words of our DOJ and the executive branch, they don't matter the way they use, because I think federal judges, whether you're a Trump appointed judge, frankly, an Obama, George W. Bush, a Reagan appointed judge, they're going to just say, yeah, that's just Trump saying a bunch of crap. We saw this case. There's nothing there. We know that this was a conviction. It doesn't matter what the head of the FBI says. But just think about, while that will be the right conclusion, what that has meant for the DOJ, our country, our legal system right now, that we can't take the word of what they're saying as being serious. Let's bring in Harry Litman, former top federal prosecutor. Harry, it raises all of these issues, doesn't it?
Sort of. So I think you're right, Ben, and no district court is going to bite on this. And there are special rules that if they're sticklers about it, and they tend to be, you can say you can't bring them now. Although you're right, the different channel would be to say, well, I'm actually innocent. But the mere label hoax, whatever the hell that means, and she doesn't know, won't do anything. Now, on the evidence, she has tried to minimize her role in very self-serving ways in that bizarre and completely inappropriate interview with the Deputy Attorney General of the United States. But it's really, as you suggest, very extensive, full-bodied. She had this claim, well, you broke your contract by trying me, and that had to do with the sweetheart deal from 2007, and nobody bit on that. So I don't see this going anywhere, but I can see a couple possibilities that are going to be, let's say, interesting, and see what happens. First, she brings this habeas action, and the district court judge says, I want to hear from the Department of Justice. And don't just say the words are hoax. Are they going to actually come forward with some kind of detailed thing that explains why it's a hoax and why she's innocent and why it was a big mistake ever to prosecute her? I would love to see that document. Then there is also, I think, Epstein, as you've pointed out, more than anybody in the country. This is the one that's not going away, that continues to stick to Trump. And I think that goes for the Congress. So there will be hearings. And now that her case has gone through and is final from the Supreme Court, she's going to be called as a witness. And I'll just say that to the extent she holds out some kind of hope that there's, let's just call it what it is, a quid pro quo. I stand up and say, Donald Trump, perfect gentleman, never did anything, and then Donald Trump gives me a pardon. They're not going to want to do that. They're going to want to hold it all over her until she has testified, and we'll see her try to, wriggle out of whatever it is. So I think that's, the other thing that the things will play out, in Congress, that they will be nervous about. Otherwise, though, there really isn't a new claim here. And on the contrary, everyone has agreed all the way up the system that the evidence against her was overwhelming, that, as you say, 20 years as a convicted sex offender, and maybe there's reason to think it was just the tip of the iceberg. But she made this technical claim that she should have had the benefit of a contract. She lost that. Anything about I actually didn't do it with the evidence that was proffered at trial, there's no habeas claim that sort of works there. And I don't see the district court judge that's going to want to bend over backwards to free her, notwithstanding all the evidence of guilt. So I think her shot is, and it would be an utter outrage, a crime, really, even though the Supreme Court has said we can't investigate, we can't bring it against the president. But her hope has to be that after things quiet down, maybe as Trump is leaving or as the Epstein hearings have completed, that Trump, who said just yesterday, He held open the possibility that he would throw down the pardon or the commutation on her. That's what she's been angling from the start, including with her self-serving and false, I think we have to say, testimony that she gave to Todd Blanche, who shouldn't have been there anyway. And that's probably the only number for her that she can place a bet on. I don't see a court doing anything with this on habeas.
Yeah, this definitely seems like it's heading towards a last day pardon path, or at least that's what's being represented to her. I almost have no doubt, I don't know this for a fact, but one can use common sense, that behind closed doors, a message has been sent to her lawyer. Hey, look, we're going to take, this is how they'll probably say it. We're going to take a real strong look at it right before. And obviously we're going to have to see just how everything develops. There's a lot of things out there, but we'll take a look at it right before, and we'll certainly assess it with a degree that I think merits the attention that you've brought to our attention. And then the lawyer will say, they'll speak in mafia language like that. And the lawyer will say, oh, I understand, but I need to be able to convey to my client that that this isn't going to go sideways, because I can't put her in a position. So I need a little bit. Look, we've known each other for a very long time, haven't we? And look, I'm not going to go further than that, but you know that we take these matters seriously, and you've known me for a long time. I do know you for a long time. You do know me for a long. There's a little dance, right, Ben? You are one sophisticated lawyer, and you know how it's done, and it's all true. I'll just say, this would be way more outrageous given what's happened and all the political controversy around Epstein than anything of a previous nature with not involving Trump, say a Mark Rich or whatever. But I'll tell you, it doesn't begin to approach the absolute incandescent outrage of pardoning everybody from January 6th, violent criminals who we all saw try to keep there from being a peaceful transfer of power. And I just want to repeat, the Supreme Court said you can't prosecute someone, but this kind of quid pro quo, doing it for his own purposes, as he's done other times, that's a crime. That's bribery or other possibilities. It would certainly be an impeachable offense, but it's a crime. It's just one that couldn't be brought. But it, as you say, if that kind of dancing is going on and winking and cheek kissing, it's a complete outrage. But we've seen, especially in pardons, I think there's no area where he's been so completely corrupt as pardons. But we've seen these outrages occur, and it would just be one more. Harry Litman, Talking Feds YouTube, Talking Fed Substack, Talking Fed Podcast. Everybody subscribe to it. Just search on your YouTube, Talking Feds, hit subscribe, be subscribed. Thanks, Harry. Thank you, Ben. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.